You will learn in this lesson how to prepare to testify in a court of law or as part of a mediation or arbitration. Although the setting and participants will vary somewhat, the overall scope of your preparations should be similar. In each of these settings, you will have done equivalent research and investigations, and you will have reached your conclusions. If you have prepared a formal expert report, you will then be subject to intense scrutiny and questioning about your work and your opinions. Each of these judicial proceedings will have attorneys on both sides and sometimes experts on both sides. A court of law may appear more formal and more intimidating, but you should not be misled into thinking that mediations and arbitrations are any less important or intense. You must still come to those settings equally well prepared with your opinions and equally well prepared to handle questioning about your methodologies and all of your work. In mediation, one person will have been selected and agreed on by both sides to serve as the mediator. Mediators are often attorneys or retired attorneys who attempt to analyze the facts of the case, interpret the findings of the experts, and seek to find reasonable and acceptable common ground for an agreement between the parties. Mediation is the most informal process and often takes place at the mediator's office. No court reporter is there to record everybody's words, and the experts are not usually sworn in under oath. However, each party will still present their case. Both experts will have their opportunities to testify, and both attorneys will have their opportunity to cross-examine the experts. In addition, the mediator can choose to pose a variety of clarifying questions to the experts. The mediator's goal is to help resolve the issue by bringing his or her intelligence to evaluate the dispute and to help resolve it. Arbitration is less formal and less expensive than a trial, although more expensive than mediation. The American Arbitration Association sets the fee schedules for its members. Oftentimes, binding arbitration is used, in which both parties agree in advance that the decision reached by the arbitrator regarding the outcome will be accepted. The same questioning and cross-examination by attorneys and additional questions by the arbitrator goes on in this judicial forum. While it has the lesser formality of our mediation, binding arbitration incorporates even more finality than a typical courtroom decision. Since the results of arbitration are generally final, it is almost always a less costly approach than going to court and trial. Let's talk about another federal rule of evidence, number 706. One additional appointment that you may receive is that of a master or court-appointed expert. The appointment is defined by Rule 706 in the Federal Rules of Evidence and spells out the responsibilities, burdens, and to an extent the compensation. To save money, both sides in the case will sometimes agree on a single expert witness to act impartially, to review the evidence, to perform the same analyses and investigations, and to come to a set of final opinions. A key tactic to realize here is that the position of court-appointed expert represents a truly balanced opportunity for an expert to analyze evidence, run tests, perform analyses, conclude opinions, and truly influence the judicial process. You will report the results of your work in this setting to a judge who will finalize his ruling based on your objective analysis. This can be more fun than usual because neither side expects you to tilt your work toward them. Both sides have agreed to pay half your costs, and you have no other expert trying to counter what you have to say. Since they are trying to save money, you usually do not even have any depositions or cross-examinations by attorneys on what you have done. Nevertheless, according to Rule 706, you are still subject to possible depositions, which, interestingly, can include questions from both sides, as well as cross-examinations by the court and either party to the suit. I have been retained multiple times as a court-appointed expert. Each time I did my work, reported my findings, and the judge made his ruling. In each case, the facts that I uncovered were, I thought, clear, and the attorneys had agreed in advance that there would be no deposition or cross-examination, so both cases ended with my reported opinion and the judge's ruling. However, it's interesting to note that the losing side in each of these matters often still disputes the findings and may attempt to either hire you afterwards to help them with an appeal or with a related follow-on lawsuit. Obviously, it would save them much effort and cost to have an expert who already knows the facts, rather than having to hire a new expert. It still felt unethical for me to work for one side after being hired by both to help the court in the matter. I did wrestle with the fact that it would have been easy money, since I had already done the work once, to understand the case fully. If you arrive at that point, you can make your own decision. This role only appears after you have been an expert witness for a while, and you gain a reputation for thoroughness, professionalism, and objectivity. But you will love it when it happens to you.